Evening. Chances are your doctor spends a lot of money on medical malpractice insurance.
But a case before the Ohio Supreme Court could shift the cost of some doctors' mistakes from insurance companies to you, the taxpayer. The I-Team's Hagit Lamore joins us to explain. Hagit?
Millions of dollars are at stake as Ohio's highest court considers this case. It builds on a giant leap the Supreme Court took in 2006 with the case of a local man, Keith Theobald.
Keith Theobald was a healthy, fit father of two when another driver caused a chain reaction that left him paralyzed. But surgery the next day cost him more.
I would have never expected to wake up totally blind and never be able to see again.
There's a plate of crackers on your left.
Theobald sued the doctors, alleging oxygen deprivation led to the blindness and forced him to need round-the-clock care. In the end, the Ohio Supreme Court ruled that because the doctors had signed an agreement with the University of Cincinnati Medical School to let students observe as they operate, the justices determined the doctors to be state employees who get immunity from lawsuits if they make mistakes. The ruling means that in some cases, patients now have to sue the state rather than the doctor. Even if you successfully sue the state for your doctor's mistake, the most you can win is $250,000. And that comes from the taxpayers, not the doctor or his insurer.
Our first case is 09-1735.
This month, the court considered a new case some experts say could add up to 8,000 Ohio doctors to the ones already getting immunity.
Larry Engel versus the University of Toledo College of Medicine.
It would be huge. It would have a very large, significant financial impact and be a drain on the general fund of the state of Ohio.
John Fisher represents a Henry County man who sued this doctor. The patient didn't know the doctor had signed as a volunteer with the University of Toledo Medical School to let their students watch him operate. An unpaid volunteer whose attorney says now deserves immunity too.
Having thus been appointed by the university and acting in the course of his officially assigned duties at the time of the care and treatment here, he was an officer or employee as the statute is defined.
So if we accept what your position is in the pleadings, what we do then is we take what could be the liability of a private insurer and transfer that to the taxpayers of Ohio.
That's what the appeals court says to do, to let doctors who get paid or just volunteer at public hospitals become immune, even in their private practice.
We could conceivably be bringing in all of their mistakes that occur when no student is present.
You could. You don't want a situation where agencies and institutions are out there and wake up one morning and are told that, in fact, there are 8,000 additional people who are on their ranks who were never there.
But that's what could happen if the Supreme Court agrees to uphold this decision, further expanding the number of doctors who get immunity but don't have to tell their patients they're immune.
A physician has no duty to tell a patient, I work for the state. I'm an employee of the state. I'm an officer of the state. I'm going to be immune if I mess this up. There's no obligation, according to this court, to tell someone that.
The Supreme Court could take weeks or months to issue its decision. In the meantime, anyone seeing a doctor should ask, do you have a teaching deal with a state medical school like UC's? And if you do get injured and consult with a lawyer, malpractice attorneys tell us your lawyer should file 2 lawsuits, one against your doctor in common pleas court and another against the state in the court of claims to make sure your case is heard one way or another. Clyde.
All right, Hagit.